my guest for this hour. Federal prosecutor and actually former federal prosecutor and former Department of Justice senior attorney Tammy Allison. Tammy, great to see you tonight.
Good to see you, Michael.
All right, so we got a lot to talk about tonight, but I want to start here with our Tennessee v. Billy Ray Turner. On the stand, Jimmy Martin. I was, again, taken aback a little bit by his demeanor. His information was, I guess it was okay for the state, but again, a lot of it centered around communications between he and Shara Wright, and Billy Ray Turner then getting involved to go towards the opportunity to kill Lorenzen Wright. That didn't work out so well. Your thoughts on Jimmy Ray Martin and his time on the stand so far?
You know, Michael, I thought that Mr. Martin's testimony came across as very credible, actually. He seemed like he was relaxed. He seemed like he was being very authentic, and he was sticking to his script. I think what he was trying to do was just really pinpoint it as, you know, I was around, but I don't really got much to do with it. You need to be looking at this other dude over here and his ex-wife that already pleaded guilty. That's how it came across to me. And to me, whenever I saw the jurors leaning in and listening to him, he's telling a story. He's painting a picture. He's helping the jury visualize it, right? So they're leaning in, taking notes. And from my experience, a witness like that tends to be more credible.
Wow, that's interesting because, again, you're talking about how he's, you know, so, and I agree with you. He's characterizing this like it was really those guys. I was kind of along for the ride, and it was really Shara and Billy Ray. But when they do that, that to me, it's interesting because, again, we don't know how jurors are reacting to it. But that whole thing is what makes me feel like that takes away from his credibility as opposed to add credibility.
You know, I think the demeanor of a witness, even if what he's saying substantively, you know, we're experts in this, you know, it takes away from his credibility to a juror, right? And juries are a cross-section of your peers in the community. They are going to lean in. They don't know. They are listening to how he's talking, how he's being very comfortable, very casual. And in the regular world, not the legal world, that is something that tends to lead to credibility and someone that's telling the truth. That's just someone that, as opposed to someone who is like rehearsed.
Fair enough. All right. You know, quickly, we're talking about his demeanor and everything. Let's take a listen to some of his testimony today on direct, talking about a meeting regarding this party or the whole plot to kill Lorenzen Wright. Let's take a listen. All right, looks like we're having trouble with the sound on that particular piece of tape, which is fine because I wanted to move on a little bit here to talk about the phone records expert, Tammy. We heard testimony from him regarding, you know, the phone records and where they place the various individuals. And we've seen from other trials that can be very, very strong testimony. I want to get a sense from you as to you think whether the cross-examination put a dent in some of that, because I think they were clear that even though it put him in certain areas, they could not put him in specific places. And this prosecution, they have to put the gun in the hand of Billy Ray Turner at the crime scene committing this crime.
Yes, Michael. So a huge dent was placed with this expert's testimony regarding the cell phones. And the fact that, like you said, having a lot of circumstantial evidence is great, but having the weapon that killed this individual in the hands of Mr. Turner is what is going to be needed in order for the jury to find this defendant guilty beyond a reasonable doubt. And as we always talk about, all the defense needs to raise is doubt. In the testimony that we heard regarding the cell phones, not necessarily placing him there, not necessarily placing the gun in his hand as the individual who shot this victim, it raises doubt. And that's all they need is doubt so that the jury can deliberate and possibly come back with a not guilty verdict.
So do you think this jury is going to be willing now to take the leap that he was in the area at the time of this murder? Again, can't place him at the actual scene. But again, this is a guy with a lot of problems in his past. He's cavorting and he's clearly communicating with others who have admitted to being part of this conspiracy. One has already pled guilty and the other one is clearly on the stand now testifying that Billy Ray was a part of it. Are they going to be willing to take that leap?
You know, you never know with juries, right? But given what's happened today with the questions that the jury is asking, very specific questions that they are asking, and they want clarity on this line of testimony that they heard. They want that clarity. I do not think that the jury is just going to take a leap if it doesn't make sense to them. It has to make sense and the dots have to be connected, because as we've seen, this jury is very attentive and they want their questions answered before they're even able to move on to the next topic or the next testimony or the next witness.
You know, that is an excellent point, Tammy, because my takeaway from the questions by the jury is exactly that they are also being exacting. And they want to make sure that all this information they're hearing, how it lines up. And so they're not going to make any leaps. They want it to all make sense. And I think at the end of the day, that helps the defense. Do you agree?
I do. I absolutely do think that helps the defense, because the defense, once again, to all of the viewers out there, all they have to do is raise doubt, because the burden of proof in any criminal case is beyond a reasonable doubt. So once the defense is able to raise doubt and we have jurors asking very specific questions, it's showing that the jury is like, well, make it make sense. It doesn't make sense. That equals doubt.
Absolutely. Couldn't agree more. All right, Tammy, stand by. We're going to take a quick break. Coming up next, we're going to take a closer look at the case of WNBA star Brittany Griner. She's still being detained in Russia after being caught with vape cartridges filled with hashish oil. We're going to have new details on how long she could remain detained. And then later in our Talk Back segment, Jussie Smollett's release from jail got a lot of attention online, especially from you, our viewers. So coming up later, we're going to share some of your comments right here on Court TV. So keep it here on your front row seat to justice.
App today.
Hello and welcome back to Court TV Live. I'm Michael Ayala. Our next story is one you may have heard about. A two-time Olympic gold medalist and WNBA All-Star, widely considered the best female basketball player ever, Brittany Griner is being detained by Russian authorities. She has been in lockup since February 17th, when she was arrested at a Russian airport after customs agents allegedly found vape cartridges with liquid cannabis or hashish oil in her bag. We are now learning that she will likely remain in detention through May 19th. This is according to a Russian state news agency. Now, Griner plays with the Phoenix Mercury in the U.S. and spends her offseason playing for a Russian women's basketball team. Griner is just 31 years old, and her situation comes as tensions between U.S. and Russia are strained over Russia's invasion of Ukraine. Now, according to authorities, she's being investigated for possible distribution and could face a maximum of 10 years in prison. The U.S. State Department has said that they have been, quote, doing everything we can to support Brittany Griner, to support her family, and to work with them to do everything we can to see that she is treated appropriately and to seek her release. A member of a state-backed panel in Russia says Griner has been sharing a cell with two other women accused of narcotics offenses. Griner seems to be holding up well. Her cellmates speak English and are helping her communicate with staff. But there is the issue of her height. At 6'9", the cells and beds aren't quite made for someone of her stature. Now, she has received support from teammates, fans, and friends from around the world. And a petition on change.org calling for her release recently had over 64,000 signatures, making it one of the most popular pages on the site. All right, still with me, former federal prosecutor and former Department of Justice senior attorney Tammy Allison. Tammy, this case interests me on a number of levels. There's the law, there's politics, and also there's, women's issues as well. We'll try to get to as many as we can. I want to start off by just asking your thoughts on what's going on here. Could this be a situation where she's a political pawn?
We never know, and very much so she could be a political pawn given the tensions that are currently happening with Russia's invasion of Ukraine and the tensions that Russia and our country, the United States of America, has had for quite some time, but you never really know. But when we talk about, narcotics, each and every country has their own rules that have to be followed and abided by. And we have to respect the judiciary, no matter if it's here in this country or if it's in Russia, as in this case.
You know what's interesting? Let's talk about if this would have happened here in America. What might have happened to Brittany Griner? Same set of circumstances. Only difference, it happened in O'Hare rather than in a Russian airport, for instance.
There's a number of things that could have happened the same or differently if it were to have happened here in this country. The word detain is being used a lot. In order to detain someone in this country, there has to be some type of suspicion of a crime being committed. Here, we know that she was caught with a vape pen, and it had either cannabis oil or hashish oil in it. In this country, it would have to be cannabis, depending on which state it is. It would have to be a certain level or percentage of THC in it in order for it to be considered legal or illegal. It just depends, right? So your example was O'Hare. She would then have to face some type of charge. She would be arraigned. She would go before a judge so she could hear what charges are brought before her. She would have an attorney and an opportunity to speak. And then there would also be a bond hearing where they could determine if she could be released pending any trial or any future court date if she were to pay a certain amount of money. And we can go on, but those are some of the things that could happen if it were to have occurred in this country.
Yeah, and obviously she's being investigated for possible distribution. There was a small amount of oil. That's something that I don't know would have happened here in the States. The final thing I wanted to touch bases on is the women issue. A lot of folks are raising this, saying that, again, she's considered the best basketball player, a female basketball player ever. So let's say this was Michael Jordan. Folks are saying, this case would be splashed across the headlines all across the country. Yet this has received coverage, but clearly not as much had it been a man. Love to get your thoughts on that.
I absolutely agree. And it's something that, on your show, I talk about a lot, the gender bias, even in death. I talk about, a lot of the cases that we cover, unarmed Black men who have been murdered by police officers and they've gone to trial. We cover it. And I mention almost every appearance how, Tatiana Jefferson was murdered by Aaron Dean in October 2019 in Texas, and Aaron Dean still doesn't have a trial date. So yes, if Brittany Griner was a man, I do believe that this would have a lot more coverage. And the only reason people are starting to talk about it is because of the disparities that we've seen and the bias in gender coverage. And that is why we continue to celebrate things like Women's History Month, which is this month.
Fair enough. All right. Tammy, stand by. We're going to take a quick break. When we come back, it's been 24 hours since Jussie Smollett was ordered out of jail pending appeal. We have new details on what happened while he was behind bars. Keep it right here on Court TV.
Call our helpline now.
We're very elated about this.
Jussie, how does it feel to be free? How does it feel to be free? Can you tell us what the past week has been like? Jussie, do you have anything to say to the judge?
This is a very serious issue that any American can lose their presumption of innocence should be an affront to us all.
He had nearly given up. The judge spent a great deal of time chastising, berating my client.
You were actually throwing a national pity party for yourself. Why would you do such a thing? Why would you? I understand you crave the attention so much.
We brought it to you as breaking news last night. Now Jussie Smollett is out of jail, spending his first full day at home since he was sentenced 1 week ago. Smollett walked out of the Cook County Jail late last night after spending 6 days behind bars. He was surrounded by security before being whisked away in an SUV. Smollett was ordered out of jail after an appeals court agreed with his defense team that he should be released pending the appeal of his conviction for lying to police. Now, yesterday, the appeals court granted his release in a 2-1 decision. Listen as Smollett's attorney, Nenye Uche, tells reporters how Smollett reacted when he got news of his release.
The first thing Jussie did was what separates us in the jail because of COVID is the glass, and he pushed his hands on the glass, and his eyes got teary, and I've never seen that because he's been very strong in there. And he said, I nearly lost hope in our constitutional system. And he did say that. He did say that. And that was his reaction. He was shocked. I think he had nearly given up.
The ruling to release Smollett came after Cook County Judge James Lynn sentenced the actor to 150 days in jail for his conviction on 5 felony counts of disorderly conduct. In an outburst immediately after the sentence was pronounced, Smollett proclaimed his innocence.
No, I would just like to say to Your Honor that I am not suicidal. That's what I was trying to say.
Okay.
I am not suicidal.
Okay.
I am not suicidal. I am innocent, and I am not suicidal. If I did this, then it means that I stuck my fist in the fears of Black Americans in this country for over 400 years and the fears of the LGBTQ community. Your Honor, I respect you and I respect the jury, but I did not do this. And I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself. And you must all know that. I respect you, Your Honor. I respect your decision. Jail time. I am not suicidal.
Okay.
I am not suicidal.
Stop talking about Black.
I am not suicidal, and I am innocent. I could have said that I was guilty a long time ago.
All right, joining me now is Court TV legal correspondent Joy Lim-Nakrin with more on this story. All right, Joy. To begin, last night we only had sketchy details on the decision by the appeals court. Walk us through that.
Yeah, so the primary reason why the appeals court decided to release Jussie is essentially that by the time he would have served his sentence, or rather by the time the appeals process would be complete, he would have already completed the whole sentence. And remember, he's appealing the underlying conviction in the first place, and his sentence was just 150 days in jail. So here's what the order said in part. Finding that the defendant has been convicted on nonviolent offenses and that this court will be unable to dispose of the instant appeal before the defendant would have served his entire sentence of incarceration, it is hereby ordered that the motion of the defendant, Jussie Smollett, to stay his sentence of incarceration and to grant him a bond, Jussie Smollett shall be released from the custody of the Cook County Sheriff upon posting of the personal recognizance bond in the amount of $150,000. So, they're not saying necessarily that at some point, post-appeal, if that fails, that he might serve a sentence at this point, but, he's challenging the conviction. So it seems unfair to make him serve the sentence when that's in question.
I agree with you. And what's interesting about that personal recognizance bond, he doesn't have to actually post any money. That's just a signature in Chicago. I know in New York it was that way, and I believe it's the same in Chicago. All right, there's also this issue, Joy, about his eating, not eating. We heard Enye Uche talk about it when he was talking to reporters. What's that all about? Yeah,
and frankly, it's still really a mystery why he's fasting. He's kind of just drinking water is what we've been able to gather. Not exactly clear why. You mentioned Enye Uche addressing it. Actually, he can explain it better than anyone. Let's listen.
Even a day spent in jail is scary. He's been here for how long? 6 days? That's scary, right? That's scary. And he hasn't eaten. Guys, he hasn't eaten for 6 days. Why? Maybe he knew spiritually something we didn't know. Right? So he hasn't eaten for 6 days.
Why?
Well, I'm sorry?
Why hasn't he eaten?
I'm going to find out from him. But maybe being in a cage for a class 4 is enough to make you not to eat. I wouldn't eat either. I'll be upset.
Yeah, obviously the suggestion is that he was just upset, very anxious, too emotionally disturbed to eat.
That's interesting. There's stories out there that perhaps he was just fasting for Lent. I mean, there's all kinds of things out there. Again, we do not know. We're expecting him to say something today, but that never materialized. We're expecting at some point he will. All right, so Joy, this case, as we know, has had many, many twists and turns, a storied history. I think it'd be instructive now to go through a timeline of the events in this case. So take us through that.
Yes, of course, because it's taken several years, in fact, for this case to unfold. So, of course, the first significant event was in January of 2019 on the 22nd. Precisely. That's when Jussie Smollett received a threatening letter at his Chicago studio. And then January 29th of that year, he reported being attacked. February 14th of 2019, police arrested the Asandaro brothers. And then February 17th, just a few days later, the possibility of a hoax attack is then investigated. February 21st, he's arrested for making a false report. By March 26, 2019, prosecutors had dismissed the charges against him. February 11th, Smollett was charged again with disorderly conduct. And then in November of last year, the jury trial began. And then December is when he was ultimately found guilty. And then March 10th, we brought you live on our air as the judge sentenced Smollett to 150 days in jail. And so you look at that sequence of events, the charges were brought, then they were dropped. Then he was recharged again, and there was a trial, and that is actually why his attorneys have been claiming double jeopardy here.
Yeah, actually, let's get into that, because that's one of their claims in their appeal. And again, that was a big part of this motion to get him out of jail. I'm sure the appeals court looked at that document, that 83-page document seeking a new trial. We've looked at it here, so take us through some of that.
Yeah, and so, you know, the defense has cited a couple of grounds for appeal. One of those, the top reason being, you know, the claim of double jeopardy, essentially that he's already served time for this crime. They're arguing, and I'll get into that, you know, a little bit later, but that this violates the double jeopardy clause of the U.S. Constitution. They're also claiming that he was denied due process in the right to a public trial because of COVID-19 restrictions, and also that the court failed to instruct the jury on the Ostendaro brothers being active accomplices. The defense is also claiming that the judge expressed verbal and nonverbal aversion towards the defense counsel. Now, here is a defense attorney, Uche, discussing some of those issues, including double jeopardy.
It is unconstitutional to charge someone twice. Mr. Smollett paid a $10,000 fine. Let me repeat it again, because our appellate courts are listening. Paid a $10,000 fine and did community service. Now, there's no time machine to go back in time to undo those things. His $10,000 fine hasn't even been returned to him, right? And then you re-indict the case and you give him 30 months probation for a Class 4 felony with a man with no criminal record, felony record. 30 months probation, you give him 150 days in jail. You give him what else? You make him do restitution of $120,000, and then you give him the maximum fines. You know, and there's something wrong with that. We've been complaining about the disparate treatment of African Americans in the judicial system, regardless of what you think about this case. Some people might think Mr. Smollett is guilty. I disagree. We all disagree. But that's okay. You're entitled to your opinion. But the real question is, should black men be walked into jail for a Class 4 felony? Shame on you if you think they should. That's a disgrace. It's wrong.
Yeah, so obviously you hear Uche claiming that this is double jeopardy. He was already sentenced, that this was an issue already settled, right? The first time around with the charges. And the prosecution categorically denies that. They say essentially they dropped the charges at that time because, you know, they didn't have the evidence at that time to build the case. And when they did, then they came back and they prosecuted. And essentially their argument is the first time around, they brought charges, they dropped them, but they didn't actually prosecute. They also argue regarding the sentence, that it wasn't a sentence, that essentially what Uche is calling a fine was not a fine. It was the $10,000 in bond. Basically, Smollett and his team said, you guys can keep it. We'll just drop the charges, kind of thing. And that's what happened. And he volunteered to do community service, is what the state is saying. Yeah,
it is a really interesting issue because, as you mentioned, both sides have interesting arguments, and it really could go either way. So it'll be interesting to see how that all turns out. But the wheels of justice have to turn, and it's going to take some time, which is again why he was let out by the appeals court. All right, thank you so much, Joylyn Macron. Truly appreciate your reporting on this. Let me bring in back my guest, former federal prosecutor and former Department of Justice Senior Attorney Tammy Allison. All right, folks were calling for the freedom of Justice Smollett. I don't know how many, but there were some. I don't know if you were one of them, but he is now free. I want to get your thoughts on this decision by the appeals court.
You know, the decision by the appeals court, as you all just described, is accurate. You know, he has the right to be released on this bond pending the appeal because we don't want him serving the entire sentence if, in fact, his appeal results in the case being reversed and remanded. So my thoughts on that is a procedural thing that happens, and that does not mean that he is innocent at all.
Exactly. I want folks to understand the appeals court's not saying he's innocent. I would imagine, let me ask you this real quick. When they're making this consideration, and you're talking about letting someone out, he's a nonviolent offender. When you look at letting someone out on bond, the issue is he a flight risk or is he a danger to the community? I think it's clear to say, no one's suggesting at all that those things apply to Jussie Smollett. So my question to you is, did they or do they take into account the strength of the appeals, or is it strictly interest of justice and they look at those factors?
They only look at the interest of justice. I can say that with 100% certainty. No appeals court is looking at the strength of the appeal without going through the entire appellate process first. That would defeat the purpose. So it's a procedural matter that he is entitled to be released without having to serve the entire sentence that he was convicted of for, before the appeal has the chance to go through, not because of the strength or weakness of the appeal. I want to be very clear on that.
All right, fantastic. Thanks for clearing that up for us. The issue at hand, or one of the major issues in that appeal, Tammy, is this double jeopardy issue. Now, you heard Joy explain some of it. I want to give you a little bit more details and then to get your thoughts on it. Basically, what Dan Webb, who was the special prosecutor, he looked into what happened. Here's what he said happened. Kim Foxx, who was the prosecutor at the time, recused herself from the case, but she didn't do it officially. So when she then appointed another prosecutor, that appointment was flawed. He was not in a position to do anything with this case. So anything he did in dismissing charges was invalid. That's their claim. So what do you make of that? Do you think there's a real double jeopardy issue here regarding the fact that he did in fact surrender the $10,000, he did agree to do community service, and the charges were dropped?
Michael, that's a very complicated question. And I want to be very careful not to do what I heard a couple of people doing, which is conflating what double jeopardy is with procedural defects in a case, which could bring rise to other constitutional matters. It could be double jeopardy, or it could just be a deal was on the table that he accepted, and then they took it away and he was found guilty by this jury. And this is something that we saw recently in the case of Bill Cosby, where there was a procedural defect that led to his conviction getting vacated and him being released. And that was something that at the time, Bill Cosby's attorney, Monique Presley, continued to argue that she had to deal with the prosecutors not to charge him. But then after he was convicted and served some time, that conviction was then vacated. So I want to be very careful to say it could be double jeopardy. It could be something else similar to the case of Bill Cosby, but who knows? We have to wait until we see it all play out.
Fair enough, and I'm glad you brought up that Bill Cosby case, because Kim Foxx, in defending what went on at the time when they decided to dismiss the charges, claims that she did in this case what a lot of prosecutors do all the time. They figure things out, make deals. They're in the trenches. They're elected to do that. That's what she did. Let me call up her. She wrote an op-ed for the Sun-Times, which is the paper of record out there in Chicago. Here's what she had to say. Given the reputational price that Smollett paid, the $10,000 bond that we held, and the fact that he'd never been accused of a violent crime, my office made the decision not to further pursue a criminal conviction. This story should have ended there, as thousands upon thousands of non-prosecuted cases do every day. She goes on to say, rather than working, actually, she says this was the criminal prosecution of a hoax, and likens it to the fact there's all kind of open murder cases in Chicago that required much more time. She goes on to say, rather than working collaboratively to stem rising crime or free the wrongly convicted, a small group of people hijacked the judicial system to enact what is best described as mob justice. And so I liken that to the case of Cosby, because the agreement there was questioned, it was problematic, but it was honored. Here it was not. Your thoughts on that?
Listen, there's a lot going on here, and I have to be super careful with what I say, because I really do not want the viewers to misunderstand anything here. What Kim Foxx is saying is she had a deal with Jussie. The deal was the deal. But for whatever reason, new charges were brought. A jury has found him guilty. This is very similar, as I stated, to what happened in the Bill Cosby case. This has nothing to do with if anyone thinks that Jussie is guilty or innocent. I think he's guilty, okay? But this is procedural, okay? And I think that his attorney Uche, he summarized it perfectly. I really don't have anything to add to what he said at that press conference. Whether you think this man is guilty or not, he has a constitutional right, okay, for several different things that are at play here. But I also want to be very careful not to conflate our push for criminal justice reform with what Jussie is saying, that he ain't suicidal, raising up his fist. Nah, don't do that. You're not Nelson Mandela. Like, you're doing the most. Stop, okay? That's completely different than procedural defects that could have made him not entitled to his constitutional rights as a U.S. citizen. okay? This is me saying that very fresh white rope from Home Depot was a hoax, in my opinion, okay? But at the same time, as a United States citizen, he has a constitutional right not to be tried again whenever he already cut a deal with a prosecutor. Like, make it make sense. And I am not defending this man at all. Like, where's Lee Daniels? Where is Taraji P. Henson, okay?
Yeah.
Like,
they were there early on, Tammy, but they've kind of disappeared now. But your point is extremely well taken. No matter what you think about Jussie, there are serious constitutional issues here that need to be addressed. If this was in fact double jeopardy, then this needs to be dealt with a different way. All right, stand by, Tammy. We're going to take a break. After just days in jail, Jussie Smollett was released from prison, and people online had a lot to say about it. When we come back, we're going to read some of your responses to this developing story. Stick around. We'll be right back here on Court TV.
Chelsea, how does it feel to be free?
Anything you want to say for yourself?
How does it feel to be free? Can you tell us what the past week has been like? Jesse, do you have anything to say to the judge?
After just 5 days in jail, Jussie Smollett was released from prison. Now, according to court documents, he is released pending an appeal of his conviction, in part because of COVID concerns and fears about his safety. So for today's Talkback segment, we gather your reactions to his release. All right, still with me, former federal prosecutor and former Department of Justice Senior Attorney Tammy Allison. All right, Tammy, our first comment comes from Tanya. She says, I truly feel this last trial was double jeopardy. This case was actually heard before, and he paid a $10,000 fine in community service. Now, a different DA took him to trial. There are people that have had less harsh sentences for violent crimes. And that second part, we'll leave that for a second. But just to be clear, he wasn't tried at all. This didn't appear in court or anything. This was something that was worked out between prosecutors and him. And one quick question for you, Tammy. If charges are dismissed, and they're not dismissed without prejudice or with prejudice, that can have a determination as to whether those charges can be brought up again, correct?
Yes, it does matter if they can be brought again, if it's dismissed with prejudice or without prejudice. But in this situation, you know, I think like you stated, this was not a situation where he was tried. This was a situation where the prosecutor worked out a deal with him, and the deal was the deal. And we see that the deal did not become a deal because he got convicted by a jury. So It is what it is.
Yep, and in the end, he did get convicted by a jury, right? Our next comment comes from Sean. He says, I would have stayed in jail while my legal team fought to get my case overturned. So that way, if they deny my case later, I would have time already in. I mean, that's a choice he may have made. Jail is not a place a lot of people want to go to. Makes sense for him to come on out and wait to see how things turn out.
Absolutely correct. I don't know who that person is or what they're talking about, but like we stated earlier, you know, the process procedurally with an appeal is you don't want him to serve the entire sentence whenever the appeal is pending, and he's going to serve the whole sentence by the time the appeal gets going. So it's a procedural issue.
There you go. All right, Tammy, thank you so much for being with me tonight. Always appreciate your presence on the show. You have a great night. I'm Michael Ayala. It's been a pleasure being with you as well. Coming up next in Closing Arguments, Vinnie Politan takes a look at the biggest moments in the Billy Ray Turner trial today. So keep it right here on Court TV, your front row seat to justice.